South Korea's Supreme Court 3 years ago ordered Japanese firms to compensate victims of wartime forced labor. But on Monday, the Seoul Central District Court issued a completely different ruling in a separate case. The plaintiffs lost in what was the largest ever wartime labor damages suit targeting Japanese firms.
85 South Korean victims of wartime forced labor and their families filed a lawsuit 6 years ago against 16 Japanese companies seeking compensation. The plaintiffs sought 100 million won each, becoming the largest damages lawsuit to date related to wartime forced labor. The first and last court hearing took place last month after 6 long years of little action due to lack of response from Japanese firms. In the Monday ruling, the Seoul court dismissed the case, saying the plaintiffs had limited litigation rights. The court cited the 1965 agreement between Seoul and Tokyo on resolving colonial-era issues. It said that individual compensation claims were covered by that treaty. The ruling suggests that individual rights can't be exercised through lawsuits in South Korea, while the right to seek such compensation against Japanese firms remains. This completely contradicts verdicts reached by the Supreme Court 3 years ago. In similar lawsuits in 2018, the top court ruled that the 1965 treaty does not apply to individual rights of claim. And the court at the time ordered Japanese firms to compensate labor victims.
현 재판부 판결은요, 기존 대법원 판결하고 정반대 대치되는 판결입니다. 그래서 항소해야 할 예정입니다.
16 civic groups have strongly criticized the latest ruling, calling it nonsensical. They said that courts may not abide by Supreme Court precedents on a case-by-case basis, but to reach a completely opposing decision when there has been little change to circumstance is quite difficult to comprehend.